What does it look like? Looks good. Guys, happy Friday, everyone. Welcome to another edition of the Texas Torch Live and Alive. Hottie, go do what you got to do. Yes, sir. Yes, ma'am. This is us doing what we have to do. This afternoon, we have mediation on a case, and I want to talk about that a little bit because mediation sometimes should be like a form of meditation where all the parties should kind of get together to try to create resolve, but not try to create resolve where they try to pressure another side and say, well, you know what, even though we haven't given you our defendant, or in this case, the driver's passenger in the 18-wheeler who were hiding from you, or the manager on duty who knows who that passenger was that we're hiding from, or the violation of confidential leaks with the courts. Guys, if you have issues with your defendant out there, with your plaintiff, with your client as a lawyer, don't violate the code of ethics. You can't file a motion saying we've tried to reach our client 10 times, and because we can't reach this defendant or this plaintiff, we're going to withdraw because we can't communicate with them. It's a violation of the code of ethics, which is a difficult double-edged sword. How do you get around it? You just kind of say it vaguely. At this time, Your Honor, we're having complications with the case. The judge is not going to say, well, what kind of the judges are smart. They're judges. They understand the rules. They understand you're protecting yourself while protecting your client, and both clients at that also, right? Because in a way, the insurance carriers are your clients as well, but you have to think about them when withdrawing, because now they have to either try to locate that individual you represented and lost control of or hire another firm. And in this case here, this all started with an adjuster named Jeff Joyce from an insurance company, and he said, Hottie, I know you, 2017, Hottie, I know you. I remember you from Allstate. I heard about you. I punched him into my system, never seen him. Never seen him ever on any cases that we have. What does that mean? That means he heard about us. Something happened on their side they didn't appreciate, and they saw that was us fighting them. And you know what I told them was what I have on the back of this suit right here, and I'm going to try to see if y'all can see it. Does it show? Miss Jessica, Miss Angel, can y'all see this?
Yes,
Does
sir.
it show? Yeah, let me see if I can zoom in. What does it say? It says, don't with me, huh?
Yes, sir.
Yeah, sick.
Yep.
Yeah, please don't with me, man. And if you do, don't stop with me. And in this case, they really, this adjuster said, Hottie, you're just going to come to mediation and take whatever we give you. Oh, yeah? That's how it is? Yep. We're going to pound you, and you're just going to come and take whatever 2017-18. You think he appreciated in 2019 we set the standard with one of the most trials in the nation for a law firm our size, 30 trials to verdict? 30. 30, not 3, 30. Unprecedented. I want to say thank you to all the judges, especially the ones in Harris County who set us for 27 of those 30, 26 of those 30. Thank you for having confidence that the Hottie Law Firm is always going to be prepared to take any case all the way to trial at any time. For the most part, we're always ready. And in this case, after the adjuster wanted to posture a little bit, he hired a law firm called Canty Hanger. Big law firm, nationwide law firm. They stepped in and brought in a law firm called Eclat, E-C-L-A-T, which means like, I guess in Florida, you can name your law firm out of, like Eclat, which is like, a French term or something for very like prestigiously professional. And, even though we violated confidentiality and ethics violations, even though we disclosed confidential information when we mediated with James Doyle. And in the other video, I said Jim Doyle, but it's James Doyle. Remember that mediator, James Doyle? James Doyle said, Hottie, I could have settled this case. It's really hard to negotiate with the Hottie, but this mediator, James Doyle, that the defendants compelled the courts to assign him to the case, they were in the defendant's pocket. I got a wallet or something in my pocket that's red, like my suit. I don't have mediators in my pocket. I don't go to mediation hoping that the mediator who's my friend is going to twist the arm of the other side. I don't need you to. The mediator, if anything, we've made the job of mediators very simple because they just go on the other side and it's like it's Hottie. Well, what does that mean? Well, you called and asked me before mediation, can you do a Hottie mediation? Okay, yeah. What does that mean? Exactly. What does that mean? The case has gotten to a point to where you're in trouble and we don't even look at the merits of it. We don't even look at the facts. I don't care that your 18-wheeler smashed into the back of my client. A lot of these cases, when you poke holes like Swiss cheese and Canty Hanger gets kicked off the case and they bring Munch Hart, Miss Brenna Lerman. I don't know Miss Brenna Lerman, but James Doyle, the mediator they selected, surely did, because when she showed up to mediation last time alone, she popped up in the Zoom. Oh, hey, Brenna. That's just Brenna. What do you mean that's just Brenna? Like your friend? Like, well, hey, Brenna, like your friend? Remember, if you're a mediator out there, impartial and unbiased, even if we're in a Zoom setting or a live setting like this, you can't, oh, that's just that lawyer. What do you mean? Like, y'all are best friends like that? You just disclosed that she's very close to you. That's just Brenna. And then when we started, even though they have like 4 pro hoc lawyers from Florida, they had Canty Hanger, Ryan Valdez, they let him go onto the case. They brought in Munch Hart with Brenna Lerman and maybe a few other lawyers there. 5, 6 lawyers on the case, they only sent Brenna. And when I told the mediator, you got all these lawyers and we're ordered by the court. How come there's not a representative of the insurance company? He had his excuses. There's no claims handler, no one from the company, nope, just Brenna. You know what he said? Brenna's a big girl. She can handle this. First of all, she's a lady. She's an attorney. A big girl is like a 6-year-old. You're a big girl now. You can put your shoes on by yourself. Very disrespectful, Mr. James Doyle, for you to say Brenna's a big girl, to use that as an excuse that she's okay to be in there alone on a court-ordered mediation. What do you think happened when he refused to give me an opening statement? He refused to allow us to open during mediation. And irrespective of refusing to allow us to open, I wasn't going to handle a mediation that's court-ordered without representative of an insurance company or carrier, or the company 18-wheeler carrier, someone that the person writing the check, when it's court-ordered, it says in there, that person must be there. Mediation blew up. James Doyle went and disclosed confidential information. All of these mediators out there that think screenshotting a Zoom session or you in the plaintiff's room and disclosing that online is no, that's not confidential, breaching confidential. Breaching confidential in a mediation is when the mediator goes and tells the other side what we told the mediator. And in this case, I told the other side, I was like, that's not cool, man. I feel like you're working for the other side because you wanted to start this mediation without doing an opening and said, Brenna's in there alone. She's a big girl. She can handle this. Unbelievable. You went and divulged all that information that they put in motions to the court. The worst part about all this is they work together to violate the code of ethics, the lawyer's creed that we're governed by, and to just divulge confidential information that was said in mediation. They lined up $22,000 in damages and asked the court to put me in jail last week, 2 weeks ago. They lost every motion. They have spent over $100,000 on this case. And we mediate again today because after they lost all the hearings and all the waste of time motions and just pounded and pounded and pounded and pounded, I get an email that says, hey, Hadi, I know it's been 18 months and I haven't called you once. I'm from Florida. I haven't emailed you once, Mr. Kevin Ross and Dino from Eclat Law Firm from Florida. But I appreciate the banter and the fussing and the posturing, but this is always about money. Nope, it's not. It's not about money. It's about respect. It was about Jeff Joyce saying, Hadi, I'm going to teach you a lesson, and you're just going to take what I give you. Okay, you spent $100,000+ to teach me a lesson. What lesson was that? That you sent an email saying, I would rather pay you money than put it in my report or use my money that I put in my report? No. Another violation of code of ethics. You can't negotiate. If you give the insurance company that you do not represent a report of what your costs that you anticipate might be, which you told them 40, it's already been over 100 because you're messing with the Hadi Law Firm. You can't email me saying I want to take some of that and put it in your client's pocket. 2 completely separate pots. Very unprofessional. And to say how you appreciate the posturing and the fighting, we don't posture here at the Hadi Law Firm. No way. And you'll find out today. If you're watching this, you probably isn't, but I'll let him know during today's mediation that I already discussed what's going to happen. You have no choice but to pay 10 times damages today. I'm going to come back up here and make another video after you pay 10 times damages. And if you don't, then it is what it is. I guess we go back to playing this game of posturing, Mr. Ross. Guys, mediation should be an avenue of resolution, but it should not be a form of intimidation. All parties who are associated with the case must be present, especially if it's court-ordered. We have been able to ask the courts politely to have the defendant. What I never understood is how come the plaintiff who filed the lawsuit must be at mediation, but the defendant who's saying it's not my fault, God hurt you, you were hurt before I smashed into your car and killed you, and has to show up to trial. How come that person does not have to show up to every single mediation? Because the defense lawyers and the insurance companies don't want to see the garbage that they're doing. Don't want to, don't worry about our client. We haven't even talked to him for 6 months. We'll just keep dragging it out. Don't worry. They were deported? Oh, what do you mean? Our client got arrested? They're relocated because of COVID? They're in the military overseas? Let's use all that excuses to keep making this case more difficult on our insured and drag it out as long as possible. That's why the defendants never show up to mediation. Because where they think we never discuss aspects of our case with our clients, they never discuss. Guys, defense counsels don't have to go and try to sign up a client. They don't have to go and try to hire sign up people that were injured or harmed. Most defense counsels don't even know how to sign up a case to draft the plaintiff's petition to file with the courts. But they want to come and put my shoes on. They want to come and sit at mediation and tell me our case doesn't have a certain value. Most defense counsels out there have never tried a case, but they want to come and say, this is what this case is worth. Okay. You know how we negotiate now? We ran out of authority. Well, what do you mean? This is our offer. Well, we can't reach that offer. We don't have it valued at that. That's cool. But I ran out of authority. Well, what does that mean? Well, you just told me that your adjuster ran out of authority, right? Yeah, okay. Our clients ran out of authority. They are not giving us authority to keep coming down. Let's go to trial. Changes everything. Guys, I hope all these videos help enlighten. The case where they just got sanctioned 20, 30,000, they try to sanction me for that and they lost, try to put me in jail, and now they're waving a white flag. Unbelievable that after coming in from Florida, violating our rules and ethics, lawyers' creed, just smearing stuff all over. And at the end of the day, guys, all of these defense counsels come and try to take a jab at me, which is okay, right, guys?
Yes, sir.
Yes, sir.
Yeah, because we all roll together. You take a hit off me, it bounces off and hits other people, and we take the hit together. You're not going to come and scare or intimidate us to come and take pennies on the dollar or take something because you pounded the file. Eclat Law Firm, Jeff Joyce, Kevin Ross Andino, y'all made this about fighting and posturing. This is the same thing I put in the other video. Y'all heard that lawyer say, Hadi, you want to fight?
Yes, sir.
Here. Guys, if y'all want to fight, I have my own video game. Whenever we launch it, you can just download it and fight. You don't even have to threaten to fight or make it seem like you want to fight. I'm always ready to fight, guys. I got 3 boys, man. I fight with them all day, every day. You think I'm not going to want to at least fight with words and writing? Guys, knock out the insurance companies and their defense lawyers, please. Don't sit around letting them come and depose your plaintiffs and then hide their people. Don't go to mediation unless you're 100% prepared. Medicals are filed, you depose doctors, you depose corporate reps, defendants. Because if not, they're just going to go sit there and drag it out and make up excuses as to why they can't make an offer. Because you haven't exposed all the issues and holes in the case that initially they just wanted to deny. And speaking of initially wanting to deny, We got our first offer from Walmart pre-suit this week after 11 years. Right, guys?
Yes, sir.
After 11 years, Walmart gave us the first offer this week. Pre-suit, following a demand that we sent. You think they're just a little bit tired of losing or winning, getting appealed, losing pain? I think so. And at the end of the day, that's where the value is. You might put effort and work into your practice or firm or into your case or your client now, today. You might not realize the benefit of it until 2-3 years later. 11 years for Walmart to give us our first offer. Reasonable, and not even reasonable, first offer. Because every time you set up a claim with Walmart, they send you a denial letter. No facts, nothing. You send a demand, denial letter, demand, denial letter. Okay. Heidi, go do what you, Heidi, stop. Stop doing what you got to do. We're tired of spending hundreds of thousands of dollars on a $20,000 case. Okay. Well, unfortunately for y'all, I don't know any other way. And I hope I can create a path or foundation for anyone and everyone else out there that wants to fight these cases and stand up for their benefits and rights when they've been harmed, or their clients' benefits and rights when they've been harmed. Guys, happy Friday. God bless. Hopefully next week we talk about how we got 20 times damages at mediation today on this case that they have 6 lawyers try to put me in jail and have spent over $100,000. And now saying, let's finish posturing, please. We don't posture. See, look, I can't. I'm slouching, right? I can't even posture. We're going to let the tiger out today. God bless, guys. Happy Friday.